So ladies and gentlemen, good morning, good afternoon, good evening, and welcome to this highly anticipated webinar on the integration effort to the East African community. My name is Faith Masharia, and I'm honored to be a moderator for today's session. I'm a partner at ALN Kenya. I specialize in cross-border trade disputes within the East Africa community at the East Africa Court of Justice and through mediation and arbitration through various forums. I'm currently the chairperson of the Trade and Regional Integration Committee of the East Africa Law Society, and this committee has members from the 7 members of partner states of the EAC, including the DRC Congo, and these are lawyers states. One of the key mandates of this committee is to push for regional integration and trade through various ways, such as this webinar, where we build the capacity of the residents, the practitioners in these areas in matters of regional trade and integration, as well as strategic litigation at the East Africa Court of Justice on matters that pertain to infringement of the treaty establishing the East Africa community. It is my privilege to guide our discussions this afternoon, morning, or evening as we explore the emerging trends and opportunities within the East Africa integration process. Now, we've walked a long journey as the East Africa community. Now, over the last 22 years, we have made significant progress towards this journey of integration, but the agenda is far from finished. But it is clearly on the right path, despite the various challenges that we face. Now, this journey commenced way back in 2000 and is underpinned by 4 main protocols. We have the Customs Union, the Common Market Protocol, the Monetary Union, which once fully implemented, should pave way toward the goal of the political federation. I think at this point, it's worth mentioning for the benefit of our participants that there have been national consultations ongoing for the drafting of the constitution of the EAC Political Confederation, and it may be worth being on the lookout if you intend to give your views on this critical step of the EAC integration. Now, the East Africa community is at an exciting point in its journey with various policies, various initiatives, shifts in focus that we have seen that are shaping and they continue to shape the integration efforts. Now, for example, just to mention a recent development, it is that during the 21st Extraordinary Summit of the EAC Heads of States, they adopted a verification report for the Republic of Somalia to join the East Africa community. So if accepted to join the East African community, then the Republic of Somalia will be the 8th member of the EAC. Now, throughout this webinar, we will have the privilege of hearing from esteemed experts who will share their valuable insights. And my hope is that we'll be able to gain a deep understanding of the current stage of integration, and most importantly, the potential opportunities, advantages available in various sectors. Now, as we navigate this webinar, we encourage active participation and engagement from all attendees. Please feel free to share your thoughts, ask questions, interact with our speakers, as well as fellow participants through the chat platform. I can see some of our attendees have already started making use of the chat platform, which is very encouraging. Now, just looking at the list, I do note that we have participation from Kenya, from Rwanda, from Burundi, from Tanzania, from South Sudan, and DRC Congo, as well as Uganda. And we want just to take this, and I just want to encourage us to take this opportunity to network with your colleagues from these countries that I've just mentioned. Now, before we commence formally our session, I would like to extend my gratitude to the organizers of this webinar. This is the East Africa Law Society, our distinguished speakers who I'll be introducing shortly, and all the participants who have joined us today. I'm pretty sure that your presence and contribution will make this webinar a valuable and enriching experience. Now, without further ado, let's embark on this journey to explore the emerging trends and opportunities within the East Africa integration process. And it is my delight to introduce to us our first speaker. This is Professor Migai Akech. If I can just ask the professor to switch on his video. Professor, thank you, sir. So Professor Migai Akech holds a doctoral degree in law and a Master of Law degree in Trade Regulation from New York University School of Law, a Master of Law degree from the University of Cambridge, a bachelor's degree in law first-class honors from the University of Nairobi. He is a fellow of the Chartered Institute of Arbitrators, a member of the Kenya National Chamber of Commerce and Industry. He's also a member of the American Chamber of Commerce Kenya branch. Professor Migai Akech is also a lecturer at the University of Nairobi School of Law. He is an accomplished legal scholar and practitioner with an extensive knowledge base and experience in governance, regulatory compliance, and trade regulation. Now, some of his notable engagements include that he's currently developing a private sector charter for the East African Business Council. He has advised the government of Kenya in the negotiation of an international free trade agreement. He is a prolific author and has published widely on legal and public policy issues, including privatization and democracy in East Africa. This is the East African Educational Publishers 2009. He's also published on regulation of trade in genetically modified foods. It's also published on the African Growth and Opportunity Act, implications for Kenya trade and development. This is on the New York University Journal for International Law and Politics. Professor, welcome.
Thank you very much, Faith, and thank you very much, the East African Law Society, for inviting me to participate in this important event. I hope that I am audible.
We can hear you well, Professor.
All right, so I can go ahead?
Yes, please.
Thank you very much, Faith. So what I thought I should talk about, or rather what I've been asked to talk about, is the status of the EAC integration process. So I'm going to do 4 things. One, to set the discussion in context. I think it's always good to think of regional integration in terms of its various stages or levels, because countries engage in regional integration at different levels, which entail different commitments. And then to use those parameters to look at the status of regional integration in the East African community briefly. And then I want to talk about some 2 obstacles that I see in terms of deepening regional integration in the East African community. And I want to ask a question. So I was asked to talk about opportunities, but I think I want to throw this back to the lawyers as a challenge. And that challenge, I think, will create tremendous opportunities. And the question I'm asking is, how can lawyers facilitate deeper integration in the East African community? And I'm putting this in the context of what is happening, particularly this idea of attaining a political federation. So as you're aware, I mean, if you look at the theory, there are various levels of regional integration. And these levels tend to be incremental or additive. So at the very bottom, you have what is called the preferential trade area. And in this kind of regional initiative or regional integration initiative, the members apply lower tariffs to the imports that are produced by other members than to imports that are produced by non-members. The next level, in terms of you moving up, so the next higher level is the free trade area. Now, the free trade area is simply a PTA, preferential trade area, but now it doesn't have tariffs, or the members do not impose tariffs on imports from other members. The next higher level is a customs union. And a customs union is a regional integration initiative in which the members impose common tariffs on non-members. So, for example, now we've heard of, in the context of the East African community, the first, second, third, and fourth bands of the common external tariffs. The fourth band being the highest, and it's imposed on certain goods at the rate of 35%. The idea is to discourage certain imports as much as possible so that you encourage the growth of industry in the customs union. And in a customs union, also members may cede sovereignty to a single customs administration. Next higher up is the common market. Now, a common market enhances the customs union and allows a free movement of the factors of production. You're talking about capital, you're talking about labor or services across national borders within the integration area. So, for example, Kenyans can easily cross and go and work in Uganda, in DRC, in Sudan, etc. Next, higher up is the economic or monetary union. And here, you're really talking of a single market. All tariffs have been removed for trade between the members. Hence, you have a uniform market or a single market. There's free movement of labor. There is a harmonized, or there are harmonized tariff rates. The members have a common monetary and fiscal policy, and they also have a common currency. If the members are even more ambitious, then the next higher level that they'd want to attain is a political union or federation. A halfway house, which is the conversation that we're talking about in the context of the EAC now, is a confederation. So the federation here, you're really talking about one government, a common government in which the members cede considerable sovereignty to the regional government, to that common government. And that is a conversation that we're having today, among others, because there are issues around the implementation of the customs union, the common market, and the monetary union. So all of this is happening concurrently in many ways, because as you will see, the EAC has made some achievements along that pendulum, if you wish. Now, the thing to note is if you're looking at regional integration initiatives in Africa, the good news is that the East African community is the most integrated of the economic communities that we have. And it's made tremendous achievements, as Faith was pointing out. And we go back, obviously, you'll recall the history that Kenya, Uganda, and Tanzania used to have an East African community in the 60s and the 70s, but which collapsed in 1977 or thereabouts. In the early 90s, 1993 to be precise, Kenya, Uganda, and Tanzania then decided to revive the EAC agenda. And that happened when they entered into the agreement into an agreement for the establishment of the Permanent Tripartite Commission for the East African Cooperation. That happened in November of 1993. They then, 3 years later, launched a secretariat of that Permanent Tripartite Commission. And that commission is a precursor of today's EAC Secretariat. It sat in Arusha. The EAC Secretariat, as you know, sits in Arusha. The EAC Treaty, as we know it now, then came into being in 1999 in November, entering into force in 2000, thereby creating the East African community as we know it today. Subsequently, there was established the Customs Union, which became operational in June of 2005. And that Customs Union became fully fledged in 2010 because there was a 5-year transition period from the FTA to the Customs Union. Then the East African Common Market Protocol was established, entering into force in July of 2010. Thereafter, the community adopted a monetary union protocol, which was adopted in November of 2013. The expectation was that the monetary union would be created by 2024. That has not happened for various reasons. So the creation of the monetary union has been pushed to the year 2031. Importantly, in terms of the political federation, the heads of state and government of the EAC resolved at a special summit that they held in Nairobi in August of 2004 to fast track the establishment of what is called the East African Political Federation. But subsequently, the summits of the heads of state and government decided to turn the EAC first into a confederation by this year, 2023, as a stepping stone for becoming a political federation. Obviously, that hasn't happened, but that is the thinking anyway. So I want to talk about the obstacles now, the obstacles to integration in the EAC as I see them, or from what I see in practice and from my work as an academic. I see two interlinked obstacles, and that has to relate to one, the lack of or the insufficiency of political will, and number two, the prevalence and growth, if you wish, of non-tariff barriers. If you look at the East African Community Treaty, to be precise, Article 5, Subarticle 2, the member states appreciate that they will not attain the political federation objective if they do not address these obstacles. In other words, they acknowledge that a political federation will only be achieved if there is effective implementation of the prior stages of integration. And the effective implementation of the prior stages of integration, as I see it, is being frustrated in some respects, both by the lack of or the insufficiency of political will and the prevalence and growth of non-tariff barriers. So let's talk about political will. You cannot have regional integration without political will. If you compare the East African community to the European Union, for example, it is noteworthy that the EU is a supranational organization in the sense that its member states have ceded a lot of power to the Union. So the Union can make political decisions. It has the political will to make decisions on behalf of the members. Contrast that with regional initiatives in our context, whether you're talking about the umbrella body, the African Union, or the many regional economic communities that we have. They are all intergovernmental institutions. That means that they only move when the most resistant member is persuaded. They only move through consensus. And so you require the political will of all of the member states to be able to move ahead. And also, the member states give the Union very little powers. The member states fundamentally retain their sovereignty. That's a critical difference in terms of this question of political will. And in our context, I'm talking about the East African community, while you find that the political leadership often declares political support for the integration agenda, they're not always committed to it. And so the EAC fundamentally remains an intergovernmental organization in which the political leadership in the member states determine the pace of integration and sometimes even frustrate it. I'll give you examples. Recently, as far back as 2019, you recall the differences between Rwanda and Uganda that resulted in the shutdown of their borders, which impeded regional trade tremendously. Similarly, around the same time, the borders between Rwanda and Burundi have been shut down, again for a considerable period of time. And so if you're looking at it from that perspective, then the member states need to grant more powers to the union if the pace of integration is to increase. And if you're looking at the levels of integration, you see we've not really quite achieved the customs union. We've not really quite achieved the monetary union. And so how can we achieve the political union when these other levels have not been implemented fully? And so that is why the confederation or the federation agenda becomes important. And above all, it will be important that this agenda is driven by the people, by the citizens of East Africa, not the politicians. So far from the manner in which it has been done, the agenda of the federation is driven by the politicians, including an ongoing process of making what is going to be the East African Constitution. I'll get back to that in terms of, so what is it that we can do about it as lawyers, and so what are the opportunities here? The other obstacle relates to the non-tariff barriers. As you all know, free trade agreements will create winners, will create losers, and the latter often including the inefficient producers. Unfortunately, whenever that happens, the losers lobby their governments to undermine free trade. And that is why you'll have all kinds of non-tariff barriers being created. So on the one hand, you're saying, okay, let's lower tariff or eliminate tariffs, which are the quantitative barriers to trade, taxes, for example. But the way to go around that is to then introduce all kinds of non-tariff barriers. And typically, these non-tariff barriers are driven by the losing private sector, or the private sector that is interested in continuing to impose barriers to trade from outside the nation state in which they operate. What are the examples of these non-tariff barriers? You have many. You have technical barriers to trade, including product standards. You have sanitary and phytosanitary measures relating to safety of animal products, plant products, etc. Transportation and logistics can also contribute non-tariff barriers. Trade facilitation, the kinds of frustrations you see people suffering dealing with customs, for example. Countries can decide to impose embargoes or quantitative restrictions, or sometimes they can use safeguard measures, which are ostensibly there to help countries manage the impacts of trade, but are not always imposed for legitimate reasons. And that is why we always need a trade remedies regime. Kenya now has an act, a Trade Remedies Act, but it has not been operationalized. I don't know if the other countries have gone that far, but this is in the context of the country Kenya in terms of its international trade. You'd want to see a similar trade remedies regime in the other members of the EAC, but also that all of them, including Kenya, operationalize their trade remedies regime, so that we're able to monitor and see, for example, that countries are imposing safeguard measures for legitimate reasons and not as a way of erecting non-tariff barriers. In practice, you have different examples. So recently, Tanzania locked out Ugandan timber, sugar, and maize. Kenya, as you know, has been hesitant to open its markets to manufactured products from Uganda. There's the question of Uganda milk in Kenya as well. The examples abound. But to its credit, I think we have to laud the East African community for taking steps to eliminate these non-tariff barriers and avoiding new ones. What has it done? It has done a number of things. One, it has established a monitoring mechanism for the monitoring of the non-tariff barriers, and tasked the secretariat, the EAC secretariat, to maintain a regularly updated inventory of the NTBs, whether they are resolved or they have not been resolved. So that's one. Number two, it has enacted an important piece of legislation in this respect. This is the East African Community Elimination of Non-Tariff Barriers Act of 2017. And this provides a legal framework for monitoring and addressing the non-tariff barriers. And part of addressing the non-tariff barriers is the proposal in this piece of legislation to establish a committee on trade remedies. Among other things, that committee would be determining the compensation that is due for losses that are related to the non-tariff barriers. Unfortunately, that committee is not yet operational, again due to a political stalemate, which only goes to underscore the significance of political will as a prerequisite for effective integration. So that is where we are as a community. So the question then at the end that I'd like to ask is the following: how can lawyers facilitate deeper integration in the East African community? And therein lies opportunities for lawyers. And obviously from a trade law practice perspective, there are many things that lawyers can do in terms of facilitating the implementation of agreements on services. So immigration law here will be critical. Competition law will be critical, addressing abuses of market power in the community and ensuring that there's a level playing field in our markets. Lawyers can perform all kinds of advisory services. And these advisory services would be useful, for example, for businesses that are interested in terms of determining where it is most cost-effective to source the inputs, for example, or how they can make use of the rules of the trading regime to ensure that their supply chains are efficient. And I'm talking about rules of origin, for example. You know, a rule of origin is really the passport of a good. How do you determine that a good was produced in the DRC, that was produced in Kenya? If the good is some of the inputs that are used to produce that good have been sourced from different countries, how do you determine the nationality of the good? So there are many things that lawyers can do. And then obviously there is a dispute resolution, including helping the member states or even affected businesses make claims where there is unfair trade. But beyond that, I think lawyers need to drive the agenda for deepening the integration of the East African community. And as I see it, lawyers, particularly the East African Law Society, can play two critical roles to advance the regional integration agenda, particularly given the lack of or insufficiency of political will. Number one, as I have noted, regional integration initiatives in Africa suffer from a democracy deficit. Democracy deficit insofar as there is a great disconnect between the people and the East African community institutions. Take a look at how, for example, we elect the members of the East African Legislative Assembly. They are not directly elected by the people of East Africa. They are elected by, I think the countries have different mechanisms, but in Kenya, I know for example, that the members of the ELS are nominated by political parties. Does that enhance the accountability of the East African community or bring it closer to the people? I really doubt. And so my sense is that that democracy deficit can only be resolved through democratizing the East African community. And that is a process that needs to commence with the promulgation of a people-driven East African community constitution. And so here is a challenge for the East African Law Society. The EALS needs to urgently hold a conference on what I would call the East African Federation we want, we as in the people of East Africa. Its agenda would be for the people of East Africa to determine the kind of political federation that they want. Because what we have so far is a top-driven agenda. It's not a bottoms-up approach, to use a common phrase in Kenyan political parlance. And then the conference would then propose mechanisms by which the community can be directly accountable to the people. Because in many ways, when you speak to people about the East African community, they really don't know what it does. They really don't know how it concerns them. And until we bridge that gap, I don't think we will deepen integration in the East African community. The people need to own the integration agenda, because so far they do not. So that is one. Second, and this relates to the non-tariff barriers, what we really need is a study that determines the extent to which the member states have implemented the treaty and its protocols. In other words, we've done a very bad job of monitoring the extent to which the member states are implementing the treaty and its protocols. And that is a study that the East African Law Society needs to think about, either commission, participate in, but it needs to happen. And once we have that study, it could then form the baseline for monitoring and evaluating the extent to which member states are complying with the treaty and its protocols. And we can do reporting on that basis. So we can have regular reports, probably an annual report on the state of integration in the East African community. Let's call it the EALS report on integration in the EAC, for example. And I think that those kinds of outputs would be very useful in terms of holding the member states to account, because they could form the basis for strategic litigation, for example. They could form the basis for assisting citizens and businesses to enjoy the rights created by the East African Community legal regime and the trade advantages that it creates. I will stop there and thank you once again for this wonderful opportunity to speak to you about deepening integration in the East African community.
Thank you. Thank you so much, Professor Migai Akech, for that insightful, thought-provoking, challenging, informative presentation. Thank you for challenging us to stop just thinking about encouraging integration and start thinking beyond that, about deepening the integration agenda towards achieving the EAC federation we want. You have called actions on both at the individual levels as lawyers, in our corporate capacity as the East Africa Law Society lawyers coming together. And we hope those are some of the things that our lawyers will be coming out with from this webinar. And also thank you for highlighting some of the opportunities available to lawyers, especially the young lawyers practicing in the EAC community. You did mention about opportunities in the immigration sector, dispute resolution in our national courts, at the East Africa Court of Justice, arbitration, mediation through the various institutions that we have within EAC. You did mention about advisory work. You did mention about competition. I think in a nutshell, you've opened up our eyes to see the possible opportunities available to us and potentially the areas that we can expand to. Now, thank you so much, participants, for continuing to share your thoughts and connecting on the chat platform. I do encourage you to start sending your questions if you have any following from Professor Migai's presentation, even as I embark to introduce our second speaker. And this is an individual with distinguished wealth of knowledge and experience and insight, and his insight, I believe, will be able to add to already enriching discussion that we've had. So our second speaker is Mr. John Bosco Kalisa. If Mr. John Bosco Kalisa can hear me, please switch on your video. He's the Executive Director of the East African Council, the apex body of private sector associations and corporations in the East African community. He has a wealth of experience in promoting private sector development and competitiveness in the East African region. He has spent over 20 years in various capacity roles, championing the business community involvement in the East Africa region integration agenda. He has an in-depth understanding of the international, continental, and regional trade agreements. He's an expert in taxation, commerce, international trade policy, law, economics, and other areas, having studied at the leading universities in Pretoria, South Africa, and Kigali, Rwanda. He also has extensive knowledge in global trade negotiations, having been involved in a couple of them. And he's also developed deep networks with international development partners, including the USAID, Korea International Cooperation Agency, Japan International Cooperation Agency, the African Development Bank, World Bank, Trade East Africa, etc. He's also managed to build a good rapport and network with governments within the EAC and industry captains, having previously worked with the Rwanda Private Sector Federation and also with the Rwanda Ministry of Finance and Economic Planning. So today, Mr. Kalisa will share his unique perspective from the business community. He's not a lawyer, so he brings a unique way in which businesses look at the integration agenda and the opportunities that they see. Then from these opportunities, lawyers will be able to cut out what may be available for us. So he's going to share his unique perspective and valuable insight on potential advantages available in various sectors, and just to emphasize how businesses, how individuals, different stakeholders can tap into these opportunities. So we are truly privileged, Mr. John Bosco, to have you here, and it's a pleasure that you've joined us, and welcome, sir. The floor is yours.
Yeah, thank you. Thank you very much, Faith. And allow me, first of all, to commend the good effort done by East African Law Society in terms of steering the integration agenda. And I really want to thank you, thank the president and the entire legal fraternity in terms of their engagement and insight in terms of how we fast track the integration. I want to thank my brother, Professor Migai. He has ably articulated the stages of integration. We always say EAC follows what we call linear approach to integration. We started with customs union, then we moved to common market. We are negotiating monetary union, then the political federation. Those are the key stages of integration. But above all, when you look at the treaty, and again, I want to thank the lawyers, and I've been taking a keen interest in terms of reading the treaty and the annexes to the treaty. The treaty is very clear. It's very clear that EAC integration is people-centered and market-driven integration, meaning that the people must derive benefit from integration. That's what we call shared prosperity from integration. And you would also measure that through social cohesion, what we call cultural homogeneity, when people are able to engage, exchange information, work together. Then another aspect with the treaty is the market-driven. That is where I come from, private sector aid. And that resonates well with our mission and vision of EABC, creating a borderless environment for trade and investment, the EAC. Addressing obstacles that were highlighted by Professor relating to NTB, because non-tariff barriers are some of the hindrances. And when you look at the data, again, where I stand, where I sit as the CEO, we always measure integration by intra-regional trade, the growth of intra-regional trade. And we always use a comparator analysis, looking at other regional groupings in the world. When you look at the Asia, their intra-regional trade is around 60%. Europe is around 70%. When you look at the intra-regional trade in East Africa, we are barely 20%. So it means there is a lot of things that we need to do, and we need to fast track in terms of our integration agenda, so that we achieve the prosperity we want, so that we enhance our welfare of the people. And again, when you look at the integration, the rationale and essence of integration, we look at the geographical proximity. You always, in economics, we say you first your trading partner is your neighbor. That is the first. You need to trade with your neighbor, because there is a lot of similarities into cultural factors, into colonial factors, into the GDP. So when you look at the macroeconomic indicators for the EAC, you look at a lot of complementarities and similarities among countries, and that gives you a chance to develop and fast track integration agenda. So having looked into that and looking at the linear approach to integration, where EAC has come from and where we are, let me first say that we need to give a very, very round of applause to our leaders. That political leadership is there. There may be some challenges, but I was looking at the recent indicators developed by African Union. The African Union, through what we call regional economic communities, usually there are 8 legs that are recognized: COMESA, SADC, ECAS, Monetary Union, ECOWAS. These 8 legs, one of the most integrated legs is EAC. And we scored highly. They came up with 8 indicators. They scored highly in almost 6 indicators. One of the indicators that we scored highly was the social indicators, which I'll come to and explain, and which is very critical, that echoes to what Professor mentioned. It is the movement of persons. East Africa can move across the borders with ease. without any visa requirement. That was very, very, very paramount, because it was one of the assessments that was done on social integration, and we scored very high because we have even that kind of right of establishment, the right of residence, access to labor market, and access to land. I know there are some challenges in some countries, but if you go to countries like Kenya, Rwanda, people have that right to establish in any country, which is not seen in other rates, which is not seen, and that's really, we were number 2 to ECOWAS in terms of social integration, looking at the free movement of persons. And now even all countries are coming into the using of single ID, using your ID to move across. So far, 3 countries, Rwanda, Uganda, Kenya, are using a single ID. You don't need your passport. That gives you the deeper integration we are talking about. Of course, there is a lot to be done, but also there is a lot to appreciate. That's one of the indicators that is very critical. Another important aspect is infrastructure development, what we call infrastructure integration. With the EAC, private sector and others have access to our ports, the 2 ports, Port of Mombasa, Port of Dar es Salaam. But above all, the EAC has almost 16 one-stop border posts, meaning that there are still challenges. I take note of that, but at least we have those one-stop border posts, customs officials sitting in one roof and able to facilitate the movement of goods. That is really a commendable work that has been done in terms of infrastructure investment. And when you look at what we call trade corridors, EAC has the most connected corridors than other rates. So that is very important. Then we went to, I also looked at our financial integration. And when you look at the banks, KCB, Equity Bank, and other banks, now they're operating in almost all 7 EAC partner states. They have presence. That means that the legal and regulatory framework has been simplified or harmonized. Of course, there is a lot of things to do around the movement of capital, but at least we have done quite commendable. Then coming to another aspect, which looks at the environment, and the environment aspect, we are not doing very well, because that is an area that we need to work on. But I wanted also to speak on the monetary union aspects in terms of currency convertibility, in terms of looking at the clearing house, looking at the issues related to the use of our currency. So we have made some positive strides. We've made some positive strides, but there is a lot of work to be done. So having highlighted that, again, I still think that the EAC, there is a lot to be done. And one of the challenges that we've been grappling with from the private sector is the issue of NTB, which my brother highlighted very well. Because this NTB impede trade, impede movement of goods, impede movement of services. But the biggest challenge where I see the legal fraternity playing a cardinal role is the compliance, legal compliance. I remember in my previous work, we used to do what we call legal compliance audit, to look at which country is complying. The treaty is very clear. The protocol are very clear. Why countries are not complying to the obligation they committed to do. So that brings me to the point of the institutional weaknesses. We don't have institutions, but the institutions are not doing their work. It's not about the politician, it's about the institution doing their work. We have East Africa, we have the EALA is one of the institutions that need to sound a warning or a wake-up call in terms of non-compliance. We have a East African court, East African court, where these issues that are emerging, the issue related to trade dispute that would be resolved. So we need to ensure that the institutions work. The institutions work. The institution and the framework are very well articulated, well crafted, but we need to support the institutions. Some of the institutions are not doing their work on the basis of the budget. So where I also sit, I realize that, and this is the challenge, when you look at the EAC, almost 60% of its budget comes from the donors. So we need to have also as the legal fraternity to look at how we resource this institution to perform its mandate. Because when you find when you look, you compare with the European Commission or European, they fund their budget. So we can't build an institution that depends on the donor. The donor resources are very fragile. They are very volatile. We need to have strong resources, and we can get these resources as long as we are able to facilitate trade, facilitate investment in the EAC. Another aspect to which I used to keenly follow up was we used to have a common market scorecard. And we could look at the legal and the compliance across the region. That scorecard was a very good tool in terms of legal and regulatory compliance among countries. But because it was a donor funded, by that time it was funded by World Bank and the IFC, when the funds were exhausted, then we ceased to do that. And I think we have brilliant lawyers who can reactivate and work on the same tool to say this is what you can do. These are the legal and the regulatory hurdles we have. Finally, on my side, I think the key that continuous engagement between the lawyers and other stakeholders is very critical, so that we discuss, especially the media. The media also, they need to do their own homework. They need to play their role. They need to be, because the treaty is very clear. It gives them a mandate, to give them what they're supposed to do, but they are not doing their right work or their right role. So let me stop there, but I think, as I mentioned, the EAC integration is on the right track. There may be some challenges, but we are on the right track compared to other RECs. And again, our role as EABC is to ensure that we enhance the business environment by addressing those obstacles, especially the NTB that has been highlighted. Thank you very much, Faith.
Thank you. Thank you so much, Mr. Kalisa. Thank you for sharing with us your perspective from a business angle. Thank you for reminding us the one important message, that we must trade with our neighbors. You must trade with your neighbor. That is in terms of goods, in terms of services. And I know there is already an understanding between the three countries. This is Kenya and Uganda and Rwanda, where you don't need a passport to travel in these countries. You can just use your ID and be able to go to Rwanda, to Kenya, to Uganda. And we hope the other countries will be able to follow suit, so that we are able to facilitate, the fundamental, principle, the key things underlying integration, movement of goods, movement of services freely between the borders. I mean, thank you for also highlighting the key things that you've seen in terms of the infrastructure development. I think the idea of the one-stop border has been welcomed, especially with the business communities. It has eased doing business in East Africa community. We've seen the financial integration. Now banks are able to operate cross-border, and fundamentally also mentioning about our environment. We know climate change is a big theme as you're speaking now. And when you speak about movement of people, movement of goods across the country, obviously the environment is going to be impacted. So as lawyers, what are you doing to make sure that you're able to tap into that opportunity and advise your clients, as it were? Now, I think at this time, we will go to the questions and answer sessions. So I'll encourage your participants to post their questions on the Q&A chat box. I can see there are 4 questions. Maybe we can start with the first question that I'll ask Professor to help us respond to the question. Professor, if you can hear me, kindly switch on your video.
Yes, I can hear you.
Thank you so much. So this is the first question. So the first question reads, what is the difficulty for the cross-border legal practice annexed to protocol on common market to be effective in all EAC member states? I think the participants wants to know the challenges surrounding, cross-border legal practice.
To the extent that I know of them, I know that, so first of all, if you're talking about, you need to look at it from the perspective of trading services. how trade in services is regulated at the international level. And obviously, from that perspective, you will note that we have different requirements for a lawyer to be authorized to practice law in Kenya and Uganda, for example, because we see different exams. We are tested by different entities. So a need for harmonization arises. And so what is envisaged at the international level is that countries, by agreement, will then recognize one another's qualifications. So there's a process of, they called mutual, what do you call it? Mutual recognition agreements, if you can call it that way. The idea is that if I am licensed in Kenya, then if Kenya, I mean, in the context of the EAC, I should not still be required to go and sit the bar exams in Uganda in order to practice law. So Uganda would, through an agreement like that, recognize that I'm a qualified attorney and I can practice in Uganda. I think that process is ongoing. I don't think it is concluded yet. That process is ongoing so that once it is complete in the 7, or if you include Somalia, the 8 member states of the EAC, then you will be able to practice law anywhere in the region.
Yeah, thank you so much, Professor. And I think also that takes us back to the point that we made, that we are leaving some of the critical things about integration and about deepening integration to the political process, right? So that it's being pushed by the political arm, while the lawyers, we are doing very little about it. So just maybe to mention that a while back we had a bill, there was a proposed bill, that was to facilitate, cross-border legal practice. But that bill did not see the light of day because of the politics of the day at that time. But it's a high time as lawyers, in our individual capacity, in our national bars among the 7, EAC member states, to take that up and to see how we can push it, rather than totally leaving this process to a political process. Of course, there's a political arm of it, but we can also be able to participate meaningfully to push that agenda. Thank you, Professor. So we can look at the second question, that is to Mr. Kalisa. So Mr. Kalisa, there's a question from you. And the participant wants to know, how far have we progressed with the monetary protocol?
Yeah, thank you, Faith. And I want again to thank the participants for that question. Maybe before I respond to that question, this is the first question. I realized that there was the East African Community Cross-Border Legal Practice Bill 2014. 2014, and it was advocated by a good lawyer, I think, Doros, and it had articles and rules and regulation governing the legal practice across borders, but lawyers did not support the advocacy to pass there. So I think this comes to coordination, collaboration among the legal fraternity. We need to work together other than competing together, but work together. So coming back to the question on monetary union, as I highlighted, there are certain fundamental preconditions or prerequisites that are required for the monetary union to happen or to be realized. Currently, as Professor mentioned, that before you go to monetary union, you need to have achieved all the components of common market protocol, and we have not. Generally, when we do an assessment on common market, we are just around 60%. So you can't have monetary union without a fully-fledged common market. That's why there has been a request for extension so that we we're able to look at the what they call macroeconomic convergence criteria, looking at the inflation level, look at the debt level of countries. Countries are at a different level. Looking at those variables, those important variables that informs the monetary union, including establishing an institute. You remember there were debates where should it be housed? Is it in Tanzania? Is it in Uganda? So those are some of the preconditions that are required before you move towards the monetary union. So that now it has been pushed to 2030. It was supposed to happen next year, 2024, but has been pushed so that we're able to address those remaining components.
Thank you so much. And thank you again for just mentioning the 2014 bill. And maybe just going back again to the participants, just to say that, I mean, this bill was proposed by one of the lawyers at the ELS, but as Mr. Kalisa said, it was actually shot down by politicians as well as by lawyers in the different EAC countries. So if this is a conversation that the ELS is currently looking into, and we just need to, as you're saying, for lawyers to support, you know, either at the individual capacity and at the national level, if we intend to practice, you know, cross borders. And maybe just Mr. Kalisa, to come back to you, and this is from a business angle. So there's a lawyer that has asked, or a participant that has asked about business opportunities that you think are available at the DRC Congo, being the newest, you know, the newest entrant to the EAC. And maybe from that, you can be able to see what opportunities will then arise for lawyers.
Yeah, thank you. Thank you very much, Faith. Again, when I speak about integration, I look at the market. And I want again to thank our leaders by admitting DRC into the community. DRC has a population of 103 million. So from the business perspective, that's a big consumer base. Whatever you export to DRC, it's bought. So whether you are in fast-moving consumer goods, you are in the construction sector, those who are exporting cement, you are in the financial services, those who are in the banking sector, you are in tourism, DRC has a lot of potential. It is a country that has enormous potential. I was looking at the statistics. Even today at 6, we'll be having a Twitter space at 6 on opportunities in DRC. There are enormous opportunities in DRC. The challenge that has been grappling everyone to access DRC has been the security. But I'm happy that our heads of state are working on it. But in all sectors, agriculture, manufacturing, services, DRC presents enormous potential to do business, to do investment. But they are also constrained. They are constrained by their legal framework and institutions. And that's what we are trying to do, engaging the EAC, EABC. How do we bring on board the institutions, including their private sector? Currently, I'm engaging the Fédération Entreprise Congolaise, called FEC. They are a member of EABC. I was in Kinshasa in October. I will be going to Kinshasa in July. I'm leading business delegation to look at the opportunities, but the opportunities are enormous. Not only for EAC to DRC, but also DRC to EAC. The DRC investors, they are investing in various sectors of our economies. In the financial sector, in tourism, they're investing in real estate, hotels across the region. The Congolese are investing, and also in creative industries. Creative industry, that is one of arts and creative industries. DRC is very good in that. They are coming to EAC. Their music and everything. So hospitality, they are boosting, and they are boosting our hospitality industry. So there is a lot, and I think it was a right choice to admit DRC into EAC, given its potential. But again, the issues of security has been one of the challenges.
So thank you. So when you talk about that, I can see opportunities for law in the construction sector, in the finance sector, in the tourism sector, you know, disputes at the East African Court of Justice, because most of these, you know, investors are coming from EAC, you know, other partner states and going to Congo. I can see, opportunities for due diligence, opportunities for transactions, advisory work, obtaining licenses, reviews of the laws. As Mr. Kariza said, we need to bring the institutions up to date to a level of compliance with the treaty establishing the East African Community. So they will need consultancy work in terms of their laws. They need their laws redrafted, among others. As Mr. Kalisa said, there's a plethora of opportunities for both the business community and as well as lawyer. So it's just for us to look at it and be creative and to remain up to date with what is happening at the DRC as well as other partner states. Thank you so much for that. So maybe we can take, Professor, you can help us answer another question. And the question is from the participants, ask that what needs to be done to ensure that all EAC members move as one in as far as integration is concerned and discourage coalition of the willing within the community.
I think the solution is making the EAC more people-centered. As Mr. Kalisa is saying, intentionally, if you look at the treaty, it is supposed to be people-centered, I would say people-driven, people and market-driven, but that doesn't always happen. That doesn't always happen because there's a gap between the people at the bottom and the East African community. If you talk to citizens of the various member states, they will know their government, but if you ask them, what is the East African community, they will not even think that it is a government, but it is a government. It's just that we give it very little powers. So I think if we have civic education on the East African community agenda, people will then get to know that the EAC is a very significant institution in their day-to-day lives, and that they can be more involved in what it does. Because what that will then do is create pressure for governments to be accountable to their people. What typically happens now is that because government is not really driven by the need to account to their people, they can make unilateral decisions. So they decide in terms of what is in their interests as government, not in their interests as the representatives of the national of, say, Tanzania. That, I think, is a fundamental problem, and we need to find a way to bridge it. And the way to bridge it, as I keep saying, is to democratize the East African community. Starting with saying, are we East Africans? Because the idea is that we become East Africans, that we identify as East Africans, not as Kenyans, not as Congolese, not as Sudanese, but as East Africans. But what will foster the East African identity? I think it begins with constitution making and civic education.
Thank you for that. So just following shortly on that, Professor, there's a question from a participant asking whether there is a shortage of lack of trade disputes at the East African Court of Justice, or is it that the governments of the EAC partner states are avoiding to use the courts?
I think it is the design of the East African community legal system. As I said, if we are to put trade disputes at the fore of what the East African community is doing, then we need a trade remedies regime. We do not have one. And that is why they enacted that law that I was talking about, the East African Community Elimination of Non-Tariff Barriers Act of 2017. But when you look at that act also, it's not robust. It doesn't quite give you an elaborate administrative mechanism for dealing with, or judicial mechanism for dealing with trade disputes. And so you will find, therefore, that there is a preference because of the lack of a legal framework, a robust legal framework for it. There is therefore a preference among the states to resolve issues diplomatically, which doesn't always work for business. So say for example, that businesses have suffered as a result of the imposition of certain non-tariff barriers. The typical scenario is that there'll be government-to-government resolution and compensation. So the government will say, probably from some statistics, they'll say that as a result of you imposing a subsidy, we have suffered X loss. We can quantify it at X amount, and you can compensate us by giving us concessions in our trade with you in another respect. So that's how it typically works. But suppose that businesses have also suffered. Can we compensate business directly? We don't have that kind of regime. There have been cases, I think, in the EAC. For example, a private company got compensation where the Burundi customs authorities unlawfully seized a truck that was carrying perishable goods. But those cases are still rare. And part of it, I think, also is educating business and expanding the scope of our practice as practitioners of law. I should be able to tell in a situation like that, you should be able to advise your client that, look, we can also seek remedies at the regional level. Number one. Number two, we can advocate for the establishment of a more robust trade remedies regime that caters for the kinds of losses that businesses are bound to suffer when the trade rules are violated by member states. I hope that answers the question.
Yeah, it does. It does. And just also maybe just to support, your views is that there's this newsletter that came out from the Secretariat of the East Africa Community. There were some tariff barriers between partner states, and when they had the meeting, I think sometime in last month, that was May, they were able to resolve 10 non-tariff barriers, okay, as new ones came in. So you'll actually see that most of these disputes, as Professor said, they're dealt with at that level, that is between one state to another. And also just to mention that, the history of the courts, I know maybe, the participant was also asking from that perspective. They have historically dealt with a lot of matters to do with human rights violations. But increasingly, as Professor said, we've started seeing a number of trade disputes being taken at the EACJ. We know we have a couple of reported matters. We have the BAT case, that was a trade dispute from the Republic of Uganda. We had the Kyo case, which I represented, the private company from Uganda, among others. So we've actually started seeing an increase of these trade disputes at the East African Court of Justice. And I will agree with Professor that there is somehow a lack of awareness, among also the practitioners, the business community of the EACJ and the jurisdiction of the EACJ. And that calls us to think, expanding and offering alternatives to the clients when they come to us for advice, by giving them the alternative, the options that they can get some remedies, including trade remedies, for example, at the East African Court of Justice. So maybe we can take two more.
Maybe Faith, I may want to interject on.
Yes, please.
On what Professor mentioned, and we've been pushing for it, a trade remedy committee or regime, because it is clearly articulated or enshrined under customs union. It was supposed to be done, to be established. But again, it was not established given the political interests, because some countries did not ratify. So what now coming to the ECJ, one, we need to ask, is it well empowered to handle if they are empowered, do they have the capacity in terms of resources, in terms of the staffing? If they are, then there is no need for a trade remedy committee because that would be part of their mandate. That would be the part of the mandate of the ECJ in terms of resolving business-related disputes. You are right, they have resolved some of the cases, but these are high-level cases. So when you look at the configuration, the structure of our businesses, it is almost 80% SMEs, micro, small, and medium enterprises. They are not advised. They don't know even whether ECJ exists, where they can. So I think one of the recommendations, and I've been talking to a number of lawyers, having cross-border legal clinics at the borders to advise, support those micro and small enterprises to understand their rights and obligations, legal rights and obligations, so that you are able to enforce or support the ECJ in their work. Currently, to be fair to them, they are overwhelmed. They are overwhelmed, and they would do that mandate. And they have now, I think, the extended mandate, they can be able to resolve trade-related disputes.
Yeah, they had expanded mandate. There was a ratification of the, there was an extension through, how do I say, extension of the jurisdiction of the ESCJ formally. That was done, I think, sometime last year, just to enable them to do ESCJ. But you do bring good points, and that is also another opportunity for lawyers, thinking about putting up cross-border legal clinics to be able to address the residents, the markets, the businesses at a small level. So back to you, Professor, there's a question that talks about, makes a comparison with the EU. The fact that the EU has implemented an ombudsman office as a halfway measure between mediation and litigation. So the question is, should the ESC consider having a similar model to dispute resolution?
First of all, just to reiterate what Mr. Kalisa is saying, part of the challenge, I think, is in terms of capacity, is that the ESCJ itself does not have sufficient capacity in trade law, international trade law. And yes, initially the way it is its jurisdiction is couched. Trade was really not the primary emphasis, but increasingly we are seeing more and more trade disputes with the East African communities becoming more successful. So you expect that there'll be more trade disputes. So I think we need to be having this conversation also about expanding or enhancing the capacities of the ESCJ in terms of resolving trade disputes. And this is an initiative that I think we should be talking about at the East African Law Society. Having said that, on this question of whether we need an ombuds office, first of all, trade is economics. And so the primary capacity that each country needs to develop is to be able to determine whether there is fair trade economically or there is unfair trade. That means you establish a trade remedies regime so that you're able to determine whether countervailing measures have been, whether there's a subsidy, whether countervailing measures have been justified, whether safeguards have been imposed by a country in circumstances that are justified. You need a very robust regime. Once you do that, and once we do that across all the member states, then we can be talking about, okay, so here is a dispute. Here are the facts. First of all, we can determine economically that, look, this is the nature of what is happening. Kenya is dumping products in Uganda. We have established that economically through our very robust trade remedies regime. Once we do that, then we can determine where do we take the dispute. Is this a dispute that is suitable for litigation? Is it a dispute that is suitable for mediation, or this halfway house, the so-called ombuds office? But I think that is a conversation further along the road. the first thing that we need to be determining here, and that is from my good friend Selemani. Hi, Selemani. We need to be to establish these regimes for dealing with trade remedies. A good starting point would be what Kenya has done, but not operationalized, as I keep saying.
Thank you, Professor. So there's also a follow-up questions from the challenges that you highlighted that that are meeting the EAC integration process. And the question is, considering the challenges to EAC integration, don't you think that these challenges will affect after, where the RECs are envisaged as building blocks? What are your thoughts on this, Professor?
Interesting question. The African Continental Free Trade Area is, among its principles, supposed to build on the regional economic communities. And like I said, the East African community is the most advanced of the regional economic communities. So I think we are a little ahead of, or let me put it differently, the challenges that you're bound to experience at the level of the FCFTA will be different, because you see, we are dealing with a higher stage of integration. Think about it this way. The FCFTA is only a free trade area. But here we are talking about a monetary union and the political federation. So obviously, there are common challenges among the regional economic communities, but the AfCFTA takes off from where the RECs have, from the level that the RECs have reached, have attained. So it's dealing with the EAC, and the EAC, as you can see, is an advanced form of integration. So I think its challenges are bound to be somewhat different from what we'll be experiencing with the FCFT at this point.
Yes, if Faith, if I may add to what Professor is saying, is right, and when you look at the CFTA, is anchored under the principle called the Acquis principle, that it is building on what has already been agreed. In simple terms, it is consolidating, is not going to dismantle where EAC has reached. It is going to build to where EAC has already attained. So that's important principle in terms of the integration. So, but coming back to the same challenges, again, we did a simulation with the World Bank. We realized that the biggest gain is not through tariff concession or tariff reduction. The biggest gain emanates from removal of NTBs, removal of all these borders, the cooperation, what we call trade facilitation governance agents, customs, migration, standard, coming together to work together. That's the way the gains are. The gains are not through the tariff reduction and our ability to remove non-tariff barrier. So I think this is the key. That is the key within also the CFTA. And as he highlighted at the EAC, we have a monitoring, NTB monitoring mechanism in place. But even at the CFTA Secretariat, they have crafted one at the CFTA to look at those barriers, especially for the goods coming from the region to access the wider continental market. Let me say, even currently, companies like coffee company in Rwanda, tea company in Kenya, Kenya has under what we call guided trade initiative. 7 countries have been selected, 3 are coming from EAC because of our level of preparedness, because of our deeper integration agenda. So, but when you look at the challenge for those companies now exporting under guided trade initiative, the biggest challenge is the NTB. the biggest challenge now they are facing is the NTB around systems not talking to each other, customs procedures, and harmonize the legal and regulatory framework. These are the issues. The same issue we're grappling with at the EAC, they are the same issues we are grappling with at the continental level.
Thank you, Mr. Kalisa, for that addition. And I do think you make a good point, and I think Professor also made a good point that we need to bear in mind is that after builds on the existing blocks, it's not dismantling them. So it just builds on what we have already. So there's one question, and maybe Professor and Mr. Kalisa, you can be preparing to give your parting shots after this question. So the question reads, the presenter wants to know the enforcement methods on legal remedies granted at the EACJ. So maybe I can respond to that because I do practice at that court. And just to say that if you look at the treaty, the provision about enforcement provides that the enforcement will be done in accordance with the rules or the laws of enforcement of the partner states. So for example, if you get a judgment at the EACJ against the government of Kenya, Rwanda, or Burundi, then when you want to enforce that judgment, you use the national laws or of that country to enforce the judgment or the ruling, as it were. I mean, just suffice to mention that during the East African Court of Justice annual conference that was held sometime in September last year in Kampala, and I know Mr. Kalisa was there as well. They just did a high-level, analysis in terms of looking at compliance of member states of the judgments or decisions that were coming at the East African Court of Justice. And the report was quite encouraging because this has been quite a challenging. There have been quite a challenging provision of the statute, and there have been, suggestions, proposals to amend the treaty to be very specific in terms of enforcement mechanisms. But as that discussion is going on, they did an analysis, they did a review, and the report was quite encouraging to see that most of the member states, they do comply, and my word is most, not all of them, most of them substantial, actually a substantial number. I think, Mr. Kalisa, they gave us a higher percentage, as high as 90 or something, of the judgments of the East African Court of Justice against the partner states have been complied with over the years. So that's the position. There's no specific provision on enforcement. You have to go back to the rules or laws of enforcement of the national, of the partner states. But as a matter of practice, the partner states, most of them have been in compliance. Suffice to say, maybe where they don't comply, you can always take them back to, it forms a new course of action in terms of contempt of the East African Court of Justice. Now, looking at the time, I want to ask Professor maybe just to give us his parting thoughts on today's conversation.
Thank you very much, Faith. I think we've had a very important conversation today. And I like to be an optimist, and I am a Pan-Africanist. I believe in the African agenda. And I see a lot of progress. Whenever I travel across the continent, I see tremendous progress. And I think the future looks very good for Africa. We have this tremendous opportunity in the form of the African Continental Free Trade Area. It's building on what we have in our regions, like what we have in the East African community. What is missing is the citizen, really. And I think when we bring these institutions closer to the citizen, they'll be more relevant. And they'll also become better in terms of their responsiveness. Because for the institutions to work for business, they need to be accountable. For them to be accountable, we need to have mechanisms that ensure that we get the requisite political will. And like I said, it is businesses that contribute or that instigate many of these non-tariff barriers, including lawyers. The reason that we do not have East African legal practice, cross-border legal practice, is not because of some anonymous figures. It is because of lawyers.
True.
It is these lawyers that are lobbying their governments not to allow cross-border practice. When citizens have become more involved, then governments will then be asked to account for such decisions. And that is why the initiative of having a political federation, yes, it may seem like something that is still in the works, but it is much needed. And the sooner we begin having conversations about it, the sooner we begin involving the citizenry so that they own it, the better. And that is the only way that we will deepen our integrations and truly call ourselves the people of East Africa.
Thank you, Professor. Mr. Kalisa, your parting shot, please.
Yeah, thank you, Faith. Again, mine is to appreciate you. And this is really what integration means. Conversation, constructive conversation and engagement with all the actors. So in my view, it is important that we enhance our collaboration, our regular engagement and partnership. That's how we are able to address those nuances that have been identified. Second, I think, in my view, institutions matters to integration process. And I always want to challenge the lawyer. Let's review how these institutions already we have them. We have ESCJ, we have IARA. These are very strong institutions that we can work with in terms of raising the voice of the citizen, as well as addressing the trade disputes. Otherwise, I also concur with my brother, Professor, that I'm very optimistic in terms of where we are at the EAC, and so far the pace of integration is very impressive. And we can do more. We can do more together, working together, and also highlighting those issues. Finally, I think the lawyer, you have a very big task in terms of interpreting, simplifying the treaty as well as its protocols. The citizen need to understand those articles in the treaty because, again, given the nature of our economies, the nature of our citizens, it has to be simplified in the language they understand. So I think it is up to the lawyers now to work together in terms of simplicity, in terms of interpretation of the legal framework, and also guide our leaders, guide the politicians, guide the policymakers, guide the investors in the region. Thank you very much.
Thank you so much, Mr. Kalisa. Thank you so much, Professor. I think the message that we all getting from this webinar is that the EAC has done a lot in terms of the integration process. As Professor said, it's the most integrated among the economic communities that we have in Africa. But based on the challenges that have been highlighted, the insights shared by our presenters, and from the questions from our participants, I think we'll all agree that we still have some work to do. We still have some work to do as lawyers in our individual capacity, in our national bars, at the East African community level through the East African Law Society, and also just to look at what we can do to encourage and to service the business community that today has been represented by Mr. Kalisa in this webinar. I think we need to start asking ourselves these critical questions. How can we participate meaningfully in regional integration as lawyers? How many of us are participating on the national consultation process on the Constitution? Now, the partner states are in the process of drafting the Constitution for the EAC Federation. How many of us are participating by giving our views, our insight, our expertise at an individual level through our national bars and also the ELS? What is it that we are doing so that as the legal fraternity, we stop being spectators and we go beyond the ideas that we're sharing in a webinar like this one and make it practical out there. So that is a call for all of us to look into it and see what is it that we are doing. If you need to call the national bus into accountability, the ELS, if we need to do that, we have to do that. And then Professor posed a question to all of us. How do we deepen the EAC integration agenda? We've been talking about, supporting the integration agenda. He did challenge us to go deeper and think about deepening the EAC integration agenda. Do we need to democratize the EAC? I mean, these are topical issues that the lawyers, the participants in these platforms can write articles about it, can write, can hold webinars on it, can do many things about the ideas that you've come up with. Even others could actually form courses of actions before different forums. So just to see that we have come out of here with a plethora of ideas that we just need to follow up. So let me take this opportunity again to thank all of you for joining us today and being part of this insightful webinar. We hope that the discussions and the presentations, they have provided you with valuable knowledge and perspective on the topic at hand. So as we come to the end of this session, we encourage you to continue exploring and implementing the ideas and the insights that we have shared in this webinar. Remember, true learning is not limited to a single event, but it is a continuous journey of growth and improvement. I'd like to express my sincere gratitude to esteemed speakers, Professor Migaya Kech and Mr. John Bosco Kalisa, for sharing their expertise, and to also all participants for their active engagement and valuable contributions. Your presence has made this webinar a success. I hope that you have made connections and you have exchanged ideas during these sessions that will serve as a catalyst for future collaborations and advancement in the field. If you have any further questions, or if you would like to delve deeper into the topics that we've discussed today, please do not hesitate to reach out to us. I did share my email address, and I think Mr. John Bosco shared his email address, and I'll ask the good professor to share his email address. And we are here to support our ongoing learning and development. Thank you once again, and we look forward to our future endeavors together. Goodbye and have a wonderful day. Bye.